Well, welcome everybody. This is Troy Fullwood with Note University, the Master Investor Series. And today I want to talk with all of you about something pretty simple, or something that is definitely a part of our industry, that's for sure. I'm going to title this NPNs, BKs, and Custom Bulk Buys. And so let me see here. How do we want to approach this? So this is going to center around a couple of things that I've seen, a couple of things that students have brought to me, a couple of things that I've been involved in, and I'm just going to go ahead and share with you. I'm going to let you guys form your own opinion about today's call at the end. And we will be, and I will be, not we, I will be taking some questions at the end. Okay, so let's go ahead and jump right into this. So, see here, got to pull up the power slide. Okay, here we go. Okay, the first part of this, I'm going to break it down into two parts. One, we're going to talk about NPNs that are in BK, and the second part, we're going to talk about what we call custom tapes and or product. Okay, go here. So, hi Troy, and then this is, by the way, this is prefaced based on an email that I received last week. I thought it was a great email. I've received this several times in the last 30 days. Things, for whatever the reason, they kind of run in waves in our industry, which is perfectly okay. I think most industries are a lot like that. So it says, hi Troy, I'm looking at an NPL from an HML for an apartment. The taxed value is $2.65 million, and the original loan is $1.3 million. Balloon due in March of 15. Property next door has similar structure and rents, but remodeled and has 6 less units. Was sold in April for $3.8 million. Subject property needs about $300,000 in $300,000 work in common area, roof, elevator. The NOD was filed in 3/2015. Borrower enforced BK to liquidate asset by her partner, and the partner is petitioning to stop the foreclosure in July. Okay, let me make this a little bit bigger. So NOD was filed. Okay. So borrower was forced BK to liquidate asset by her partner, and the partner is petitioning to stop the foreclosure in July. The unpaid interest and fees are about $1.6 million now. The original interest rate of 11% jumped to 22% when the default went into effect. HML said since there is plenty of equity, they will not discount the note and wants all part of fee and late interest. They would sell at par, which will also includes fees, penalties, and unpaid interest, approximately $1.6 million. Okay, so that was the core email. Okay, that was what was sent to me. Now, the questions. If we pay this amount and continue with foreclosure, if sold at auction for a higher price than what's owed plus fee and unpaid interest from this point on, we can only get paid for the balance plus the 22% interest, right? The borrower would get the rest to pay for their creditors. Okay, so I guess I'll answer this question first. So let me recap this real quick before I go into answering the question. First thing here is what we have this particular student has an opportunity to buy a non-performing loan that was, and I had this conversation with him, so I can kind of fill in some details here. Buy a non-performing loan from a hard money lender. Okay, essentially, it was a hard money lender with 11% interest rates. It's been forced into 22% interest rates, and at the end of the day, what they have here is they've got a total accumulated current outstanding balance on the note, and it's a first lien note, by the way, of about $1.6 million off of an original $1.3 million loan. Now, this is on an apartment complex. The apartment complex was, along with some other assets, was forced into bankruptcy due to a partnership disagreement, or I'm not sure the ins and outs of the issue there, but nonetheless, it was due to a partnership disagreement. Now, as I explained to the student, the number one thing we have to remember, because it's in bankruptcy, okay, because this deal is in bankruptcy, the trustee of the federal bankruptcy courts now have control over this particular deal. And with the fact that this property has equity in it, the courts are going to seek to liquidate any and all assets to pay off any and all creditors, whether they are secured creditors, meaning a lien holder like this note, or they're unsecured creditors, meaning a credit card creditor as well. My point here is this, that nobody has control over this anymore, with the exception of one person, and that is the trustee, the bankruptcy trustee. Not even the judge can necessarily overrule a trustee in the matter. Okay, a trustee can 9 times out of 10 is more powerful than a judge. Okay, what they kind of say goes. Now, a lot of times the trustees will stay out of things because they could care less about it, but at the end of the day, they in turn control how this thing goes down. Now, that being said, this is considered technically an asset to the courts. Why is it considered an asset to the courts? Well, simply stated, because it has equity in it. Okay? If this, let's say the scenario was a little bit different. The property had a $1.3 million loan on it. It's now owed 1.6, but the property is only worth 1.1. Very, very common scenario over the last 7 to 10 years, or 7 to 8 years, because of the economy. And so when those kinds of scenarios are in play with a bankruptcy, the courts and the trustee could care less about that so-called asset, because now it's technically a liability. So as a lien holder, if the property has negative equity in it, as a lien holder, it's very easy for a lien holder to step up to petition the courts for what we call a relief of stay, and then to, in turn, get approval of a relief of stay, and then in turn proceed with their foreclosure. Now, the simple truth behind that is that typically only happens when there's a negative equity position on the property, okay? Because the courts and the trustees' fiduciary responsibility by federal law is to seek out any and all ways to resolve any and all debts, okay? So in this particular case, because this property by, what do you call this, because of this property being what it is, meaning that there is equity in it, they have a fiduciary responsibility to take control of the property, to sell it off at auction. And this would not be a foreclosure auction. It would be sold off at like a traditional auction, or possibly through a realtor. I mean, they have a lot of different avenues that they can pursue as a court, and they can certainly put those court orders in place to make those things happen. But when it does go and it's sold, whether it's through traditional means, meaning a realtor, or whether it's through an auction style sale, which would be through like an auction house, then all that money will go to the trustee, and the trustee will in turn divvy up the proceeds. Okay, so let's say this $2.3 million, is it 2.3 or is it 2.6? $2.6 million value, okay, with $1.3 million loan, but it's got about 1.6. So it's about $1 million equity in this deal. So that being said, if they sell it, say, for $2.1 million, which would still be $500,000 below what its tax value is, which those are the kinds of deals that investors look for, or people look for in general. And there's probably a higher value if you were to get an appraisal on it as well, because tax values tend to be lower than the traditional value. Then at the end of the day, that $500,000 would then be split up and divvied out between the other creditors in the bankruptcy, whether that's auto loans, credit card loans, IRS taxes, state taxes, property, all of those things would be part of the bankruptcy. Now, in order for that to happen, one of the things that they would require is that that an appraisal gets done on the property in order to establish its true value. Because here's what the trustee's looking at. They see this as an asset. If it had negative equity in it, it'd be considered a liability. Okay? So in a lot of bankruptcies over the last several years have been of that nature, where there's no assets in the bankruptcy, meaning that they've got a lot of unsecured creditors. The real estate they own is negative equity. The car that they own has no equity in it either. So all of these things would play a role in determining whether or not that would be a position. The key to bankruptcy courts is they want to take the paperwork, they want to review a person's financial situation, maybe ask a few other questions, dig a little deeper to come to a conclusion whether or not this case is worth pursuing, meaning are there assets to be obtained here and sold to spread the money out throughout the creditors, or is this a open and shut case where there's nothing here, the unsecured creditors are wiped out, the house or properties are either they continue to maintain the payments on them, or they give them back to the banks and they walk away with little or nothing in the end. That's the simple truth. The other side of this coin, and why they want to do those kinds of things and determine whether or not there's equity in a piece of property, like this one here as the example, is that trustee gets 10% of the deal. So in a $2.1 million sales price of this property, the trustee is going to get 10% of it, okay, for their efforts. So that's a $210,000 payday for the trustee. So you can see what motivates the trustee to find the assets and sell the assets, because, hey, they get 10% of the overall take. That hard money lender that came in at $1.3 million, chances are they're going to be made whole on their 1.3, but they may not be made whole on their 300,000 in interest. They might, but the trustee and the courts will determine that in the end based on the overall income, or based on the overall sales price of the property or sale of the property. Question number 2, if not sold at auction, then we own the property, correct? So worst case scenario is that we get 22% on our money while waiting for foreclosure, and best case scenario would be owning the building at 1.6 million with an ARV of 4.2 million. You would think that that would be the case, but keep in mind you've got a third party individual that's involved in this, meaning a trustee, and a trustee is not going to allow this to go to a foreclosure sale. Okay? They're not going to allow it at all. So, and they're aware of, the trustee on all of these cases, they're very aware of any time a lender files for a relief of stay. Okay? And they review the file and they let the judge yes or no on the matter, and you have to put in your paperwork when you file a relief of stay, you have to put in your paperwork the property that you're going after and seeking to foreclose on, what is the value of the property in regards or in comparison to the unpaid principal balance of the loan. You have to state that. So the moment you state that, hey, the value of this property is at least 2.6 million, I'm owed 1.6 million, so I want to go in and foreclose on it. And when I do, I'm taking all of my money and all of that equity is going to transfer to a new owner who purchases it. Because that's really why you foreclose on a property. As a lender, you foreclose on it so you can get all your investment back out of it, and then the property transfers to another party because they bought it at the courthouse steps. So it transfers to another party that ultimately, reaps the benefit of it, whether that's a fix and flip investor or whatever. In this particular case, it would obviously be an investor that is a multifamily investor. So a judge is not going to allow that to happen. Okay, trustee of the court is not going to allow that to happen. So at the end of the day, what we have here is we have a situation where the note holder is trying to peddle a note so that they can get out from underneath of it, because they know because they've already probably tried to get a relief of stay, and the only way they can finish or complete the foreclosure is to get a relief of stay. And the judges said, no, we're not giving that to you. Trustee said, no, we're not giving it to you either. So what they've decided to do is, hey, let's go pawn this off on some unsuspecting, uneducated investor who ultimately will pitch this as a 22% return on their money. But in the end, when the courts sell the property, that the trustee and the judge will determine what percentage of this they'll get. Now, their principal is typically protected, meaning their 1.3 is protected. But the $300,000 in interest may be a wash, depending upon how many other creditors are involved. If they're the only creditor and they sell this thing for, 2.1 million, and the trustee takes 10%, now you're talking 1.9 million. That means the lien holder is going to get 1.6, and 300,000 is going to be given back to the people involved in the bankruptcy. As you can see, even if the bankruptcy courts give back 300,000, they're still going to make their 200 grand on the deal, because that's what they're motivated by. That's the system. 3, have you bought anything at par or done deals similar to this scenario, and what are your thoughts on this deal? I've never paid par for anything, no reason to, and I've never gotten involved in a deal like this because I've already seen, I know what the bankruptcy courts can and will do. Okay, when you understand the final chapter of the book, you understand not to get involved in the first chapter because there's no money to be made there. HML required me to sign an NDA and sent me all the available docs, and is very, very protective on their side. Does anyone that I work with, including potential funding investors, or discuss the detail about this deal, need to sign too? Potentially yes, but that's kind of irrelevant at this point. To me, when I look at this deal, it's a waste of time. And the reason it's a waste of time is simply and that is because you can't make any money off of it. You're investing with the idea that you're going to, quote unquote, get the property back. Well, you potentially could, I guess. I mean, if you really wanted to play devil's advocate here, if you went in and you bought the note for $1.6 million and you had the note, and then the trustee sold the property, I guess you could buy the property at the courthouse steps for $2.1 million, but why bother doing that? My best advice I had for this particular student was, if you're really, really passionate and you really, really have to have this property, the best thing you can do is to track what's going on with this particular file and track it all the way down to when the trustee determines that, hey, this is going to go to sale and we're going to put it up for auction, or we're going to list it with a realtor, whatever that may be. Those are just a couple of options that they have. And we're going to do that. And then you can, in turn, buy it on that side of the fence. It's a lot cleaner, it's a lot easier, and reality-wise, it's probably a lot faster. Let the note holder be the note holder who currently has it now, and wait till that point in time comes, and then depending upon their asking price or the going rate or price at the auction, will determine at that point in time whether or not it's still wise to pursue. Now, the fact that there's $300,000 in upgrades that need to be done, and that this after repaired value, I think, was 4.1 or 4.2. If you came in and bought it at 2.1 million, you threw another 300 into it, that puts you at 2.4 million. It's worth 4.1. You got about $1.7 million in equity. Is that a good deal? Yes. Yes, it's a good deal. But the difference there is you're waiting until the trustee says, hey, we're selling this off. Let's go sell it. Now, the trustee may, and the courts may say, well, wait a minute. We have an appraisal here. And the appraisal says this thing's worth $3 million. So we're going to list it on the market for $3 million. And why wouldn't they? The trustee gets 10% of the deal. So instead of getting $210,000, now they get $300,000 on the deal. So as a whole, it just makes sense, and you have to understand the motivating factor of a trustee, of a bankruptcy trustee. One, they're motivated by their fee, which is 10%. And then two, they have a fiduciary responsibility to recover as much money as possible to pay off the creditors as much as possible. Whether that's a partial payment or a full payment or whatever, it just is what it is, and that's okay. That's okay. So to me, this is a better play to wait until they announce that this property is going up for sale, or that they announce that this property is going to be auctioned off, and then to follow that particular chain and see who gets the listing appointment, see who gets the responsibility of auctioning off the property, and then go forward from there. I would not personally buy this note, and I would not personally waste time trying to buy this note and work through the court system. It's a lot of extra expenses. It's a lot of extra time. And in the end, being the note holder in this particular scenario does not guarantee that you've got any control over any part of this. Primarily, and the one key ingredient that makes that the case is the fact that there's equity in this property. Okay, that there's equity in this property. All right, so custom trades. Now, this idea of custom trades has probably been around in our industry. Probably has been around this industry. Well, I was first introduced to them probably back in 2008 or 9. So with that being said, it's been around quite a long time. My point in this is that with that being said, what are the challenges with it? Well, having been a very involved person with this, okay, and I had a friend who was trying to put together a custom trade desk and all this other stuff, and really after about 6 or 7 months of working with him, realized that it was really just almost an impossible task. Okay. Now, the challenge with it is this. In the custom, quote unquote, custom trade game, and by the way, well, let me break it down, then I'll tell you my experience. So here's the email. We got an email from a student says, hey, Kim, hope this email finds you well. I made contact with a consultant at Property Investors Group. Before they can offer to do business, they are requesting your details to be forwarded to them in order to send you as many tapes as you want. Please find attached the forms. Shall I complete them on your behalf, or will you complete these and send them back to me to forward to PIG? There's a minimum take size of $2 million. I'm also waiting for 2 other hedge funds to get back to me. Thank you. Very, very exciting email. Very, very exciting email. Okay. Certainly one to make you jump up and down and dance a jig. But the truth be known, let's just call it what it is. It's wasted time. Okay. It's wasted time. And here's part of the email that I got. And it was a PDF or form that they wanted. This was their intro letter. It says, Dear buyer, you have taken an interest in our custom order program, and we appreciate the opportunity to help you with the success of your real estate business. In the buyer submission package, you will find a number of forms for you to fill out in order to make the search for your product request. Our business model allows you to see assets before they are released to the public. Like yourself, come across tapes that have been shopped around and there is no exclusivity. This is why more and more buyers are excited about this program. Below is a general outline of our protocol. Keep in mind it may be very slightly from source to source, but generally it's the same simple process. Thank you again for the trust and confidence you placed in us, and we look forward to an extremely successful business relationship. Non-performing, performing notes, and REO custom order platform. So, okay, sorry about that. So, non-performing, performing notes and custom order platform, direct with asset managers nationwide. Our platform gives investors the opportunity to custom order their non-performing, performing note and REO portfolios, all asset types from single-family residence to commercial, including multifamily, hotels, office, and retail. Notes, $2 million USD minimum. Order size, REOs, $2 million USD minimum as well. protocol. An NDA, NCND, is signed by the buyer and buyer's rep. Red flag number 1. Principal buyer submits their LOI asset criteria for the product they're requesting to purchase. Red flag number 2. A conference call will be scheduled within 24 to 48 hours between the asset manager and the buyer to further discuss the asset request, answer all questions that they may have, and go over all details pertaining to the asset, to acquiring the assets. Pretty standard. Number 4, the asset manager will compile a tape for your review. Once a buyer has completed their due diligence and decides the assets are satisfactory, then the buyer must provide earnest money deposit. The specifics of how much will be discussed between the buyer and the asset manager. Red flag number 3, 4, and 5. All right. Let me just dial this in. This is not the way the industry works. Okay? This is not the way the industry works. I wish it did. I wish it could. I wish it would. It would be amazingly simpler as a business and as a business model. But here's the simple truth. Number 1, if there was any truth to custom ordering tapes for any note buyer, REO buyer, NPN buyer, whether it be residential or commercial, the number 1 thing we'd all be looking for is to buy deals that are solely in our own backyard. For me, it would be the Phoenix marketplace. That's where I live. That's my backyard. For you, it might be Dallas or some other part of the country. Okay, which is a great concept and it's a great idea, but it's never come through. And I've gone down this road over the last several years, or not recently, but prior to the last several years, where I finally totally just put a bullet in it with several people about this idea. And the question that comes up each and every time in the midst of the deal was, you go through the interview process, you have the conversation, you fill out your LOI, and then nobody delivers anything. They don't have any tapes. They don't have any way of getting tapes. What they want and what they're looking to do is to create a relationship with as many people as humanly possible and to take their information and then to, quote unquote, shop that information around the country. Okay? To shop it around the country. But because of the mortgage-backed securities market being what it is, meaning that all of these notes, non-performing notes and REOs and things like that, they're owned by foreign entities. Okay? They're not owned by B of A, and they're not owned by Wells Fargo, and they're not owned by these institutions and banks. They're owned by the government of Japan, the government of Australia, the UK, Switzerland. They're owned by those entities. Now, the simple truth is that when they sell product off, they sell it off in a bulk package format. Okay? And they know, because of their high standing in the economic circles or world, they know who to call. Meaning, if they've got a $100 million tape or a $500 million tape, Troy Fuller from Pinnacle Investments doesn't get to go in there and cherry pick what he wants. What they do is they call up a major hedge fund or private equity fund that's on Wall Street or some other part of the world and say, hey, we're liquidating these assets. Are you interested? And most times they are, and it typically is a all or nothing trade. So they come in the door, they negotiate whatever their pay price is, and then they write the check and they get the entire portfolio. And that's the way it's done. And then that company takes out what they want. Typically it's $250,000 assets and above is what they're seeking. And then they'll sell off whatever's left to other pension plans, other pension funds that may not be as highly capitalized in those areas, and it trickles down. So to say that somebody can put together a custom tape is really, and to send it to me or to you or anybody else is really kind of a insult against our time and our knowledge. Because the truth is, if they could really put together a custom tape, why would you bother calling Troy Fullwood? I mean, I'd love to buy a custom tape if it was real, but it's not real. Why not call up Blackstone? Why not call up some of the big players and go to them and say, hey, we can put together custom tapes of REOs or notes or non-performing notes for you. What are you interested in? You know they got money. You know they're a major player. You know they've got a public image and reputation that's successful. Why not go to them? You know? And the reason they don't go to them is because they can't get them to engage and play the game with them. Okay? This quote-unquote consultant that he's in contact with, back here, contact with a consultant at Property Investors Group, and I don't even know who Property Investors Group is, but at the end of the day, that consultant is just AKA a broker, and you're involved in a broker chain. Now, typically they want 4 points, 3 to 4 points for doing these. Now, this is a modified version of what's circulated for probably about 5 years. There was this quote unquote platform trading program that you had to have a minimum $25 million to invest, and they would custom fulfill tapes for you. Well, the question I kept asking people was, hey, if there was truth to what you're saying here, and I put $25 million up to buy product, and all I want to do is buy in Phoenix, Arizona, or Southern California, heck, I'll even spread it out over 5 states. I want to buy $25 million of this product, but here's the deal. When I'm successful at buying it from you, and at the price point I want to buy it for, then I want exclusivity, and I don't want you selling this to anybody else. Because I want to buy 25 million to 50 million a month. And I'm going to pay you your 3 points. Well, if somebody's, if you're talking 3 points on 25 million, okay, and get out my calculator, make sure we got it dialed in right here. That's $750,000 a month. But here's the beauty of it. If you're the quote unquote consultant or broker and you're making that kind of money, how many more clients do you need? I mean, if you're making $750,000 a month from one guy spending $25 million a month with you, I mean, heck, let's just say it's 2 points. That's $500,000 a month. That's $6 million a year in income. How many more clients do you need? Well, the truth is, it doesn't happen. So this is that old eulogy of confusing action with results. They just live in a world of lies. They just live in a world of lies. So they go to the next person. They tell the story all over again. And they go to the next person. They tell the story all over again. And they think that something great is going to happen. They think that something good is going to happen. But at the end of the day, one, nothing ever happens. Number one, nothing ever happens. And then number two, they don't ever make any money. So what happens is this idea gets passed down or passed on to somebody else, and somebody else thinks that they can do it better. And that's why this program, I mean, it originally started at 50 million, and then it kind of got brought down to 25 million, and then it kind of got brought down to 10 million, and now it's all the way down to 2 million. Hey, all you gotta do is $2 million investment. And the reason is there's no tapes. There's not this huge data bank of NPN product or REO product on a nationwide basis that goes into one collective system where you can literally go there and just cherry pick. It's not like there's this huge data bank similar to that of the MLS. Okay, like if you're a realtor and you got access to the MLS, not only do you have access to the MLS in your home marketplace, but you also have access nationwide. So every time a house is listed with a realtor, that information is put on the MLS. Now, the truth be known is that there are a lot of houses that are sold without a realtor, that information never makes it to the MLS. Well, there's no such thing as a REO, NPN, MLS site for banks to go and list all of this product. Because if there was, trust me, we would have figured it out by now. But it just doesn't exist. Google it. Feel free to Google it. It just doesn't exist. And if it's a web-based platform, you'll find it. It may take you a little while, but you'll find it. And finding it, obviously there's, that would be a gold mine because you can go in there and just start picking products. Now, there are some company websites that have small amounts of inventory, but I wouldn't say you could custom build a tape from it. I would say if you're a street level investor and you want to go and pick up a couple of tapes or a couple of, not tapes, but a couple of notes in your neighborhood or your area of the country, that you could do that. You'd have to keep a watchful eye on it. You'd have to come to it on a regular, weekly basis or every other week type basis to pay attention to it. But at the end of the day, you could pick up your fair share of properties, but not on a basis of this nature where they're going into it. And this is probably one of the simplest ones I've ever seen, because one of the things that they took out from prior ones was they wanted to see after the call, what they wanted to see was your proof of funds. And what was happening is they would take your proof of funds with your LOI and they would start shopping it all over the internet. There were several occasions where I would get my own proof of funds and my own LOI sent back to me on somebody else's letterhead. Okay? Not what I would consider to be a very honest way to do business. But nonetheless, that's what they would do. Okay? That's what they would do. So the beauty of it is, or the point of it is, that when these things come across your desk, and they will, you spend enough time in this business and you're working it on a daily basis, which I hope all of you are, you'll see these kinds of things come across your desk. Rather than getting all starry-eyed and trying to figure out which model BMW you're going to buy this week, just delete the email and move on. Now, if you want to prove my point to yourself, feel free to follow the rabbit down the hole and fill out your LOI, fill out your list of items or deals that you want to buy, and do a phone call with the asset manager. And usually that's about as far as it gets successfully. And usually, or my experience tells me that every time I would leave a call with a quote-unquote asset manager, I would be promised all kinds of amazing things within the next 24 to 72 hours. They would be back with me. They have this product in inventory. It's no big deal. They can pull it off their trade desk. They can do all of these things. They'll assemble it in the form of a Excel spreadsheet. They'll send it over to me with all the due diligence links. And then I would sit there and I would wait. 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 And after several days, I would call them back and say, okay, where's my, oh, yeah, we're working on it. Yeah, we're almost done. We almost got it complete. And I would wait, and I would wait, and I would wait some more. And it would just continue to be a total waste of time with these people. And the scary part about it was they really thought they had something. They really thought they had all kinds of things. And because they were promised by somebody who was promised by somebody who was promised by somebody. And usually what you find is there's 4 or 5 or 6 people involved between you and the quote-unquote trade desk guy who ultimately has no intention whatsoever of doing anything of that nature, nor does he have the inventory or the ability to do that. And so at the end of the day, after a week or two, you'll come to the conclusion that you were that the other party was not truthful with you, and you will figure out that it's not worth your time anymore to pursue it. And what ultimately would happen 9 out of 10 times is about a month later, I would get an email from them saying, hey, we haven't been able to put your custom tape together, but hey, here's a tape that just happened to come across our desk. And it's got some properties that I thought you might be interested in it. Let me know. So they use this whole methodology to build up their buyer database. That's what they do. And you look at the tape, and usually a lot of times I find out that the tape that they just sent me, after waiting for 30 days, is one I've already seen 3 weeks earlier anyway. So it's a moot point. And it ends up being a waste of everybody's time. The downside or the challenge with that is now, you've given up your proof of funds info and all that, and now that's been circulated all over the internet because they're a bunch of brokers and they're running around the country with your financial information, shelling it out to anybody who will give them 10 minutes of their time. And now your financial information is in the hands of people you don't even know. And to track it is really, really difficult to do so. So the point of this whole scenario, the point of this whole situation is to avoid, that kind of business relationship because it's fruitless. Okay, it's not fruitful, it's fruitless. You won't succeed under those conditions, and neither will anybody else. Neither will anybody else. So, anybody got any questions? Let's see, let me minimize this so I can see. All right. Well, no questions coming in, but so two things we want to take away from today's call. 2 takeaways. Number one is if a deal is in bankruptcy and you're being offered to purchase the note, even at a discount. I mean, we bought notes out of bankruptcy. We bought them at a discount, and they were all performing notes, and we bought them. The courts took the money, and they paid off all the parties involved. We got the notes. But we bought it on the back side of the deal. Okay, we waited for the court to figure out all the stuff they were doing and what they wanted to do and how they could recover the money. And then once they devised that plan, then we stepped in and worked our magic and bought the deal. That's how you buy things out of bankruptcy. Okay, you don't pay par or any of that other stuff. You don't try and rescue somebody's deal because they unfortunately found themselves in that set of circumstances. Okay, don't do that. It's a high risk gamble, and one that you will probably not be very successful at. Number two, second takeaway from this is stay away from these quote unquote custom tapes, custom platform trade deals. I don't care how well written they are. I don't care who you're talking to. The bottom line is, at the end of the day, that doesn't exist. Okay. Here's also one of the reasons why it doesn't exist. The Patriot Act, which was put into existence back in 2001, okay, does not allow for that type of opportunity to exist in the financial world. Okay. So, and what I mean by that is that to commingle the assets of many banks and many investors into one site, or as they like to say, all the assets of all these investors into one site, it can't exist because it's a violation of the Patriot Act. Why is it a violation of the Patriot Act? Because the Patriot Act does not allow financial institutions to commingle. It just doesn't. Okay, and that's what that would be. And it would be, the other thing that you'd also have to get on board with, and there's some sites that have similarities to it, meaning like auction.com is a site that has everything from houses to REOs to notes. And they've done that, but they by no means do they say, hey, Troy, we can get you a custom tape, because the truth is they can't do that. When they have built their site based on going around the country and introducing their opportunity to people out there, and people come and list their homes or REOs or properties on their site, and they auction them off based on a timeline, and they get paid their money and move on down the road. So stay away from those kinds of things. If you want to chase that rabbit, feel free to do so on your own accord, on your own nickel, and then you'll understand more clearly about what it is I'm saying to you. And I'm just saying this to you because I don't want to see you waste time. I've already wasted the time at least half a dozen times. I've been fruitless every single time we've done it. And it's funny because those people we don't even do business with. They came in to our business model for a short period of time, and they took off because they figured out they lied and misrepresented everything to us, and they had shame. They were shameful. They felt guilty. They felt embarrassed. So they moved on down the road. And us, at the end of the day, we didn't make any money, but we invested a lot of hours and resources towards it, thinking that we were, hoping that we would, and got nothing out of it. So it's very much like a needle in the haystack. But, well, I don't see any questions coming across the board here. So what I'm going to do is I'm going to wrap up today's call. Those are your takeaways. These are some things to be aware of in the marketplace. It doesn't mean anybody's, trying to rip you off or any of that other stuff. I don't want to go down that road. But it does mean that pay attention to this, because it can be a huge waste of your time. Okay, huge waste of your time. And I don't want to see people wasting their time on things that aren't going to produce some kind of a powerful result in your business. All right. That being said, have a great day. Have a great week. We'll see you guys back here, same place, same time next week. Take care. God bless. Bye now.